Are you eligible for VA benefits, or does the law and the VA regulations bar you? That's the question for today, and so that's what we're going to be talking about. Regardless of the military characterization of your discharge, the law says that if you were discharged or dismissed from service under certain circumstances, you're not entitled to VA benefits. How can that be? I got an honorable discharge. Well, yeah, even if you received an honorable discharge or discharge under honorable conditions, Congress may have prohibited an award of VA benefits to you based upon the reason of your discharge. Here are 5 reasons for discharge that results in a bar to benefits. Okay, now these are the statutory bars. We're going to talk about regulatory bars in just a few minutes. Number 1, you are a conscientious objector who refused to perform military duty or refused to wear a uniform or otherwise refused to comply with lawful orders of the military. Saw a movie last night, Hacksaw Ridge, where the individual, Desmond Dawes, said, "Hey, I don't want to carry a gun." Of course, he was court-martialed. He was not discharged, but he was eventually became a hero. But there are a lot of people out there who were conscientious objectors and that were discharged from military service. Number 2, maybe you were discharged or dismissed by reason of a sentence of a general court-martial. Or number 3, if you were an officer and you resigned for the good of the service. Number 4 reason, desertion. And then number 5 is discharge as an alien during time of hostility. Those are the 5. Now there's also the one that's a discharge under other than honorable conditions issued because you were AWOL, absent without leave. Of course, you got to be absent without leave for 180 days, continuous days, but there are a lot of exceptions to that 180-day rule. There's exceptions that doesn't allow the VA to not award these benefits to you if there's compelling circumstances to warrant the reason you were AWOL. I don't understand that, but that's the way the law is. So in determining whether there were compelling reasons why you were AWOL for 180 continuous days, the VA's got to consider the totality of the circumstances, including factors other than your statements, to determine why you went AWOL. Maybe your service was really good, you'd been there for a while, and you were an exemplary soldier or midshipman or whatever you were in the military, and something just clicked, and so you went AWOL. More likely than not, you probably had a family emergency or some kind of obligation. Maybe a sick parent or somebody died or whatever it may have been. And so that, and you weren't able to get leave, so you said, "What the heck with you? I'm heading out." So now you're AWOL. And then maybe you had some kind of duties or obligations owed to third parties. I don't know what, but so the VA is going to take into account all of those things into determining whether or not the exception to the rule of the AWOL rule would apply to you. Maybe you went AWOL, but you're very young, or you were very young. Maybe your cultural background has something to do with it. Maybe your educational level. And maybe you just at that point in time you weren't very mature and you just snapped. Okay? The VA is going to consider all of that. And so the VA is going to, hopefully, the VA would carefully and sympathetically consider hardship. Maybe you went AWOL because of a death in the family or suffering. Maybe you just had a real bad case of the homesickness. I don't know. Maybe you were wounded and you said, "Man, I just can't take this and I'm out of here." But the VA is going to try to look at your state of mind and try to determine whether or not you would fit within that exception to the AWOL. So those are the reasons for the legal bars or the statutory bars. Now let's go to the regulatory bars. And these are not by Congress, these are by the VA themselves. So after the VA determines whether there are any statutory bars to you receiving benefits, they're supposed to analyze under its own regulations, criteria, whether a discharge was issued under dishonorable conditions. So a lot of times on the DD-214s, we're, as a general rule we get, it's honorable discharge, or it might have been a medical discharge, but I have seen discharges for the good of the service, and I have seen a couple of dishonorable discharges. So if you received an honorable discharge, you don't have to worry, you're not subject to the regulatory bars, okay? Now, if you received less than a full honorable discharge, the VA is going to determine whether any of their regulations bar you or preclude you from entitlement to VA benefits. Now, realize that the VA considers a discharge as having been issued under dishonorable conditions if your conduct, which your discharge is based upon, fits into any one of the following 5 categories. Here's another 5 for you. Maybe you accepted an undesirable discharge or discharge under other than honorable conditions to escape trial by general court-martial. So you were caught red-handed doing something, or maybe you just said, I can't fight these charges, I want out anyway, and so you accepted that discharge under less than honorable conditions. Maybe you're in the Navy, so you staged a mutiny. Or more likely than not, you were probably spying. There's a lot of that going on out there. I mean, you see it up in Washington a lot. Maybe you have some kind of offense involving moral turpitude. And what the heck is moral turpitude? That's a pretty broad term, okay? So this is what the VA determines as moral turpitude. Abduction with consent. I don't know how you abduct somebody with their consent, but that's what they say. Bigamy. Why would anybody want to have more than one spouse? I have trouble just keeping up with my only one there. Maybe you're smuggling, contraband, or whatever. Rape, attempted bribery, profiteering, robbery, murder, deceit, fraud, all resulting from some kind of financial harm. And this one gets me: illicit sexual relations with a fellow worker. This is called office affairs. I'm pretty sure there are a lot of office affairs going on out here in this country. So just beware, that's moral turpitude. If that was your offense, then that's a regulatory bar to VA benefits. And then if you had willful and persistent misconduct, and then homosexual acts involving aggravating circumstances or affecting the performance of your duties. We talk a little bit about willful misconduct. What is that? And the VA regulations have a definition of that. And so that willful misconduct would bar you in obtaining veteran status. Willful misconduct is defined as an act involving conscious wrongdoing or known prohibited action that involves deliberate intentional wrongdoing with knowledge of a wanton and reckless disregard of its probable consequences. That's a mouthful. Basically, it's saying that you did something really bad and you knew it was bad, and despite knowing it was bad, you did it anyway. If you know something's bad and you do it and you get caught, that's enough to bar you from obtaining veteran status. Now, the regulation goes on to clarify that if you just have like a technical violation of, say, a police regulation or ordinance, that's not going to per se constitute a willful misconduct, but you just got to be careful. For instance, I would think that a technical violation would be something like drunk driving that is an intentional act. Well, I didn't mean to get in my car. I was drunk. Well, you intended to drink. You intended the act. Maybe one DUI is not going to get you kicked out or bar you from veterans benefits. But if you are discharged because of numerous DUIs, then yes. If that DUI actually resulted in some kind of manslaughter charge, then yes. Okay? So don't drink and drive. Okay? An exception to this willful and persistent conduct bars is for minor offenses again. Minor offenses are not considered willful. Okay? The bar that seems to be present in be most difficult for the VA to adjudicators and for folks like me to determine is an offense involving moral turpitude. And we talked about moral turpitude a few minutes ago. So, and although the regulations state that an offense involving moral turpitude generally includes convictions of felonies, further regulatory guidance about this is needed, and so we need the VA to work on this because it's not clear. And I'll tell you why. So, for example, adultery is still a crime in many states, like it is here in Georgia. But if you're having a moral turpitude of an office affair, isn't that adultery? So, adultery, is that going to bar you from veterans benefits? It could. Okay? So you just got to be careful. Okay, just got to be careful. But if you received less than a full honorable discharge, are you still entitled to VA benefits? Maybe not all benefits, but you may still be entitled to VA health care for any disability incurred or aggravated during your active service in the line of duty. And I've done a video on active service. You need to check that one out. Okay? So, however, VA health care is not going to be provided for disabilities that were incurred or aggravated during the period of service that was terminated by your bad conduct discharge. So if your bad conduct caused your injury or caused an aggravation of your injury and you were discharged because of your bad conduct, all bets are off. You don't get covered. Those medical bills and all of those things are now on you. Now, there's one overriding exception to any kind of statutory or regulatory bar to VA benefits. And that is, we call it the insanity exception. People don't talk about insanity anymore. In fact, the doctors don't even diagnose somebody as being insane anymore. They would have some kind of mental illness that you would look up in the DSM-V5 to determine what that is. So, if it is established that at the time of the offense leading to your discharge, you were insane, then you're excused. Okay? So basically, because of your insanity, you were not responsible for the conduct that led to your discharge. Your insanity must have existed at the time you committed the offense that led to your discharge. It couldn't have manifested itself in the future. It couldn't have been manifest itself in the past. Although I think if you're insane in the past, you're probably insane in the present too. Further, okay, your insanity does not have to be causally connected to the misconduct, but it's got to exist at the time of the conduct. And according to the case law out there in the VA regulations, an insane person is somebody who, due to a disease, while not mentally defective or continually psychopathic, exhibits due to disease a more or less prolonged deviation from his normal behavior. So it's a disease. Insanity is a disease. Okay? the VA considers you to be insane if your mental disease caused one of these three circumstances that were listed in the regulations. Remember, DUI is not insanity. And by the way, PTSD is not insanity either. Okay? And the only people who actually diagnose insanity nowadays is the VA. So, if you've got a medical opinion relying on the VA's definition of insanity, that's great. Okay? Because, again, modern psychology and psychiatry no longer deems people insane. They don't say, hey, Dale's insane. They don't diagnose me as insane. They'll diagnose me as something other, but not insane. And note that the law judges that we have to go in front of often interpret insane in a narrow way. So to exclude veterans who clearly exhibited symptoms of PTSD or traumatic brain injury, TBIs, or other mental conditions, the definition is very narrow in the law judges. So this insanity exception, I've seen it used unsuccessfully a couple of times, but it's very, very difficult just because of the narrow interpretation of the veterans law judges. Hey folks, thank you for watching today. We really do appreciate that. Check out this video on dealing with active service, because you've got to have active service in order to even be considered for veterans benefits. So until next time, be blessed.